Order in the court, all rise please. Court is now in session. Please be seated.
Good morning, everyone. My name is Justice Herman. If counsel could please introduce themselves.
Good morning, Your Honor. My name is Lau, first initial M, and these are my colleagues from the Crown. This is Martinson's, first initial P, Bozis, first initial J, Baker, first initial H.
Good morning.
Good morning, Your Honor. My name is Sultan, first initial S, and these are my colleagues from the defense. This is Cole, first initial S, Golshan, first initial S, and Bigford, first initial J.
Good morning, everyone. And Mr. TC, is he here? Good morning, sir. All right. Are there any issues that counsel wish to raise before we get started? No? All right. Thank you. Do you wish to make an opening statement?
Yes.
Okay, go ahead.
Okay, good afternoon, Your Honor. My name is Bigford, first initial J. Okay, Your Honor, this is a case of mistaken identity. On the evening of March 10, 2010, our client, Donovan Tizzy, was at his local recreation center playing pickup basketball and spoke to the youth leader of the center about post-secondary and scholarship information. He was not in the alley when Mr. Williams was assaulted and robbed. Our client, Mr. Tizzy, is a 16-year-old youth in grade 10. While he was convicted of shoplifting 18 months ago, he has put his life in order and is on the right path. Mr. Tizzy has a part-time job, he is doing well in school, he is looking into going to college for technology and applying for scholarships. He also goes to the homework club and plays basketball 3 times a week at his local recreation center. It is anticipated that Mr. Tizzy will say he wouldn't assault and rob another youth and jeopardize his future. Today you will hear from 2 defense witnesses, Donovan Tizzy and Stephen Wong. We anticipate that Mr. Tizzy will describe that on the night in question, at about 6:00 p.m., he and his friend, Dwayne Dirks, left his apartment because he was upset about not being able to buy a new pair of basketball shoes. When prompted by his friend to steal the shoes from a store, Mr. Tizzy declined because he didn't want to jeopardize his part-time job and decided to do something constructive by spending the evening playing basketball at the local recreation center. We will also hear from Mr. Tizzy that during the evening he spoke to the youth leader of the recreation center about different college courses and scholarships. And at about 8:30 p.m., he left the recreation center by himself and walked straight home. Finally, Mr. Tizzy will describe to the court that about a month later, a police officer knocked on his apartment door and told him he was under arrest for assault causing bodily harm and robbery. The officer then picked up a pair of basketball shoes outside of Mr. Tizzy's apartment building and not inside his actual dwelling, and didn't bother to ask Mr. Tizzy about them. We anticipate that Mr. Tizzy will say he had never seen the shoes before. Our second witness, Stephen Wong, will explain that on the night in question, he was working at the recreation center and spoke to Mr. Tizzy about information on college courses and scholarships. We anticipate that Mr. Wong will describe how Mr. Tizzy's mannerism was during their discussion. We will also hear from Mr. Wong about his relationship with Mr. Tizzy and how often he sees him at the recreation center. We also anticipate that Mr. Wong will say that Mr. Tizzy has never displayed violent activity at the recreation center. Mr. Wong will also explain to the courts his particular role at the center.
All right. Thank you.
The defense will now call its first witness, Mr. Tizzy, to the stand.
All right. Mr. Clerk, then, could you please arraign Mr. TC?
Donovan Tizzy is charged that he, on or about the 10th day of March 2010, in the city of Toronto, did assault causing bodily harm Andrew Williams, contrary to Section 267B of the Criminal Code. Donovan Tizzy, how do you plead to this charge? Guilty or not guilty?
Not guilty.
Donovan Tizzy is charged that he, on or about the 10th day of March 2010, in the city of Toronto, did rob Andrew Williams, contrary to Section 343A of the Criminal Code. Donovan Tizzy, how do you plead to this charge? Guilty or not guilty?
Not guilty.
Please be seated.
Thank you. Good morning, sir.
Would you please state your name for the court?
Devon Tinsey.
Could you please spell your first and last name?
DONOVANTISI.
Would you like to affirm or swear in the Holy Book?
Swear in the book.
Do you swear that the evidence you're about to give is the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Please be seated.
School. Just one moment, please.
Objection, Your Honor.
And what is the basis for your objection?
The evidence is hearsay.
All right, any response?
Yes, Your Honor. This is basically part of the narrative as to why Donovan Tizzy is a suspect and why he was further sought out to be questioned. And also, the rumors aren't going to be used for the truth of the matter. It's just basically for the narrative as to why he was suspected.
All right, I'm prepared to admit the evidence as part of the narrative to explain the officer's actions and what happened, but not for the truth of the contents.
This is a case of mistaken identity, and the defense submits that the Crown has not proven beyond a reasonable doubt that our client, Mr. Tisi, was in contact with Mr. Williams on March 10, 2010. Mr. Tisi is a hardworking student with a bright future ahead of him. He is working with Mr. Wong at the local rec center towards scholarships and attending college. He has a job and often uses the rec center's facilities, such as the homework center or the basketball court. Mr. Tisi has elaborated that he understands a criminal charge would be detrimental to this future. He has testified that he was never in the alley and did not commit this attack. The Crown's witness, Andrew Williams, has clearly suffered a grievous attack, and as anyone would, he is seeking justice for what has been done to him. However, the defense submits that in his search for justice, Mr. Williams based his choice on a distant memory of a stressful situation that occurred some time ago. Both Crown witnesses have confirmed for the court that the lighting in the alley was poor, and the defense submits that Mr. Williams chose a photo based on a presumption and not a stable knowledge. The court has heard from both Crown witnesses that Mr. Williams thought he recognized one of the people in the photos, and only after he was prompted by Constable DiCarlo did he clarify his answer and say that he was positive. Today, the court has heard from Mr. Tisi, a credible witness, who explained that on March 10th, he left his apartment at 6 p.m. with his friend Dwayne Dirks, arrived at the local rec center at 6:40, where he played pickup basketball and later spoke to Mr. Wong about different courses and scholarships for college. Leaving the rec center at 8:30 without Mr. Dirks, Mr. Tisi walked home. Mr. Tisi further elaborated for the court that a month later, Constable DiCarlo came to his apartment, arrested him, and as they left, she picked up a pair of basketball shoes, which Mr. Tisi had not seen before, that were in fact outside the apartment building, not inside. The court also heard from Constable DiCarlo and Mr. Wong, whose combined testimonies validates Mr. Tisi's testimony. Mr. Wong confirmed for the court that he did speak to Donovan that night regarding scholarships in college, and further elaborated that there were many new people at the rec center as it was a cold month, explaining why Mr. Tisi did not recognize him. Constable DiCarlo confirmed for the court that she did pick up the basketball shoes outside the apartment and not inside it. Your Honor, today we seek an acquittal of all charges. This concludes the defense evidence. Thank you.
Thank you. Thank you, counsel, for your assistance. I'm going to take a break of a few moments to consider the evidence as well as your closing arguments, and I will return in a few moments' time and render a verdict.
All rise, please. Court is recessed. Order in the court, all rise. Court is now reconvened. Please be seated.
Okay, I'd like to thank all of you for your patience, and I would like to commend counsel for the very able jobs that you did. At this point, I would ordinarily give a detailed review and assessment of all the evidence. However, given the nature of this exercise, I am going to be very brief. Mr. Donovan Tisi has been charged with robbery and assault causing bodily harm. In particular, it is alleged that on the evening of March 10th, 2010, Mr. Tisi and another individual brutally attacked Mr. Andrew Williams and stole his running shoes. In order for Mr. Tisi to be found guilty of these offenses, the Crown must establish the essential elements of each of these two offenses beyond a reasonable doubt. I have no doubt that Mr. Williams was indeed assaulted and robbed the evening of March 10th. The sole issue in this case is whether it was Mr. Tisi who was one of the two individuals who was responsible. I do not question Mr. Williams' credibility. However, there are inherent frailties to eyewitness identification, notwithstanding that the identification is honestly made. There is an unfortunate record in this country of cases in which individuals have been wrongfully convicted on the basis of eyewitness testimony. The court, therefore, must be very cautious in relying on this testimony alone as a basis for a finding of guilt. I also found Mr. Wong to be a credible witness. I accept his testimony that he indeed did see Mr. Williams on the evening of March 10th at some point before 8 p.m. It is possible that Mr. Tissey would have both been in the alleyway the evening of March 10th, encountered Mr. Williams at that time, and then gone on to the recreation center, at which point he saw Mr. Wong. However, there was no evidence before me as to the time it would take to get from Mr. Tissey's home to the recreation center, except for Mr. Tissey's evidence. I appreciate that Mr. Williams had a horrible experience the evening of March 10th. It is understandable that he would want to see the perpetrator called to account. However, our criminal justice system requires that before someone can be found guilty of a criminal offense, their guilt must be established beyond a reasonable doubt. In the circumstances of this case, based on the evidence that I heard, I conclude that the Crown has not established its case beyond a reasonable doubt. Mr. Tissey, I would ask you to stand now. I therefore find you not guilty of the 2 offenses with which you have been charged. You are free to leave. Thank you.
All rise, please. Court is adjourned for the day.